My name is Eva Maria Svensson, and I'm a professor of law at the Department of Law at the University of Gothenburg. And I've been here since I was educated here in Gothenburg, and have for long periods been at the department and a professor since 2006. But I have also worked with other things, and except for my legal education, I have also studied theory of science, which has been important in my research. Well, I have worked with some other things as well in the I worked with immigration issues in public service, and I've also been professor in Tromsø in the north of Norway. So my main focus or my main interest is legal philosophy and feminist legal philosophy, but I've also been into various branches of the legal discipline. So I started in labor law, and I worked with family law, and constitutional law, and especially freedom of expression in relation to gender discriminatory advertisement, and some other things like indigenous issues and discrimination legislation and so on. But my main interest is this theoretical and methodological aspect of law.
Why did you start studying law? Why were you interested in it?
I started in the late 1970s with a quite radical ambition to change society, and I intended to go to tax law and work with economic crimes, because I was so upset of injustices in society connected to wealth. And I wanted to really go for the people that were, not paying the taxes they should pay. So that was my original intention. But then during my education, I started to be interested in questions that had to do with the law's relation to sex and gender.
You have researched on feminist jurisprudence?
Yes, feminist jurisprudence or feminist legal philosophy is a separate field of knowledge within legal scholarship, and it developed from a critique of the legal philosophical tradition, which claims to be universally valid, but which in reality is one-sided. Women's experiences and interests are not explicitly excluded from the domains of legal philosophy, but the abstractions, concepts, and distinctions are based on an imaginary world that can be said to be gendered. Or in other words, the legal system fits better to men than to women. But that is not to say that it doesn't fit any woman or all men.
How did feminist jurisprudence start?
When women entered the academy and started to be part of the creation or the development of knowledge, they started to realize that all the constructions, all the concepts, and when it comes to legal scholarship, also the law was constructed based on a typical male way of thinking. So I think it's kind of very logical to think that a new group entering a field changes the conditions for the field, because the new group thinks differently. And so that's why this field of knowledge was articulated in the middle of the 20th century. So now, in the Nordic context, the knowledge field has been there for 50 years. And when I was a young student in the beginning of 1980s, it was quite unknown and it was new. So I had heard nothing about it during my education to become a lawyer. But then when I started to do research, I found these specific context or these networks that were interested in feminist legal scholarship. And then it was not only legal philosophy, but also more legal scholarship in general with a feminist perspective. And since then, it has the field has developed in many ways. The philosophical part of the field has developed new concepts to grasp the reality or the law in order to reflect upon the law and how it could be differently. But also the topics that have been studied by feminist legal scholars have, of course, expanded over time. So the most common topics in the beginning was, as I mentioned before, labor law, family law, and so on. But in recent years, feminist scholars have entered most all branches of law. So talking about business law, for instance, or tax law, there are feminist scholars dealing with this as well. But legal philosophy, the main task for legal philosophy is actually to create concept, to grasp how we think about law and to be able to reflect upon whether law could be differently, and that is what feminist legal philosophy do.
You have written a thesis entitled Genus or Rätt. Would that be gender and law in English?
Well, the concepts of sex and gender are difficult in English. They have different meanings depending on context and time. But when it translated to the Scandinavian languages, it's even more difficult. So starting with the English distinction between sex and gender, it was originally a way to be able to approach the biological aspect of being a woman or a man, and that was sex. And then the sociological aspect or the social aspect was gender. So in order to make that distinction, it was possible to say that some things are natural and not possible to change, and some things are possible to change. And basically, we have the same possibility to think in this way in the Scandinavian languages. But in Danish and Norwegian, the word kön or kön,
Yeah.
kön or kön is used for both sex and gender. And in Sweden, we use the same words as sex and gender in English. But when it comes to the theory of gender system theory, gender has a specific meaning. So it's both the same as the social aspect of sex gender, but it also connected to a special theory made by the historian Yvonne Hiedman. And that theory is quite important for legal scholars in the Swedish context because the political area of gender equality, which produces also legislation aiming at gender equality between men and women, that political area actually took this theory, the gender system theory, and expressed it as its knowledge base in the beginning of the 1990s. So when we then later in the 1990s got this prohibition of purchase of sex in Sweden, it was based on this knowledge ground, this theory of gender system theory, which perceives purchase of sex as an expression of an unequal relation between a man and women.
So is it prohibited in Sweden?
Yes, it's prohibited.
Constitution is?
No. It's prohibited to buy sex.
I see.
So it's the typical man, often the man, but not always, that is criminalized, not the seller or often the women, but it could be men, of course, as well. So this way of understanding what is in most languages talked about as prostitution, it's a way of understanding it as an institution in society that is an expression of a gender unequal relation. So that's why the buyer is criminalized, to say that it's not okay to buy another person to use as a mean for yourself. So when in an international context, the two opposite positions are talked about as the abolishment of prostitution, which often means the criminalization of the seller, or the more liberal approach that everyone is allowed to do whatever they want to do with their body. That's a pro-prostitution position. None of these positions actually talk about the Swedish position, that is a totally different one, that is based on a structural understanding of an institution that is an expression of gender inequality. So that kind of legislation that was adopted in 1999 was the result of this gender system theory. And also we introduced a special crime called gross violation of a woman's peace, also in the 1990s. Also
which is what?
This theory. That crime is a way of saying that what women all often experience in close relationships, that they are beaten repeatedly, perhaps not very severe each time, but repeatedly, and they live in a relation where their self-dignity is decreasing over time as well. That kind of situation is criminalized through this specific crime. So that is also a very unique innovation, so to speak, and based on this gender system theory. So being a feminist legal scholar in Sweden, it's means that this theory is part of the legislation. So you have to use this theory, and it's very close to use gender in that sense. So gender is, in a theoretical sense, an analytical tool to be able to reflect upon how law had impact on the relationship between men and women. But then, in more recent years, the concept of gender has also been more of a category part of the discrimination legislation. So now we have the discrimination grounds, that you are protected from discrimination not only on the basis of which sex you have, if you are a woman or man, but also based on your gender identity and your sexual orientation.
So gender fluidity.
Yes, so gender fluidity has, well, the legislation is not really built on fluidity, but gender has become more categories than it used to be. So gender today is both this theoretical concept and a concept that is implemented in the legislation regarding anti-discrimination legislation. Talking about my thesis,
Yes.
it was not really about gender equality or discrimination. It was a legal philosophical thesis, and through gender as an analytical and theoretical tool, I was able to reflect on how we think about law. And the traditional way of thinking about law is that it is a closed system, is detached from human beings. It is natural, so to speak, is evident, it's objective, neutral, impartial, and it is equal to whoever you want to adopt it on. And it's also that theories about law, for instance, legal positivism, legal realism, or natural law, and all of the theories about law, they tend to explain law as something universal, that is the same in any time and any place. And it's also thinking about the human being as the human being is transformed to a legal subject, and the legal subject is abstract. It has no sex, it has no physical body, it has no ethnicity, it has nothing. It's an abstract construction. And this legal subject is autonomous, and it has a free will to choose for oneself. And the only limit is if you interfere with some other legal subject's choice, then it comes to a limit, so to speak. And all these kind of basic presumptions that I mentioned now, I could challenge through the analytical and theoretical tool of gender, because I could show that the legal subject is not an abstract thing. On the contrary, the legal subject that is the model, so to speak, in the legislation, it has features that are typical for men. For instance, labor law is based on a person working full-time during the whole life, or from during the adult life at least. And we know that women more often do not work full-time, and they have also interferences when they get child and so on, and take care responsibilities. But the insurance systems and the rights coming with an employment is based upon this model that fits more to men's life than women's. And you can take any area of the law and you can show how the law is constructed based upon a certain understanding of the human being. So that's how I could show that the legal subject is not abstract. And the other thing regarding the legal subject was that the legal subject is considered in law to be autonomous. But when it comes to most women's lives, or many women's lives, they are dependent on a spouse or a partner, partially, and anyway, not fully today, not in the Nordic countries, but partially, or they are dependent on the state for subsidies of a certain kind. So this perception of the human being as autonomous and independent fits quite bad if you look at most or many women at least. And if you look at children, they are certainly dependent on other human beings. So that's, I mean, indirectly you could say that the findings of my thesis can be used to argue for more gender equality, but it was not the main focus. The focus was more to say that, look here, the law, how we think about the law, hinder us from seeing certain things.
How can we achieve equality between men, women, and all the genders using law?
Well, I'm not so sure that we ever reach full equality, but of course we must try to achieve it. And the first thing then is to acknowledge that the law is a human product, and it has to change because the context is changing all the time. And we have to acknowledge that all human beings have not the same conditions. So I think the role of the law must be to counteract patterns of inequality in society. So when it comes to, for instance, redistribution through the tax system, that's one way to create equality in a material economic sense. But then, of course, to recognize that human beings have different characteristics like sex, ethnicity, and so on, may also make it possible to counteract certain inequalities in society, to reach for a result that is more equal. So equality is also a tricky concept, of course, and it can be interpreted in many ways. But what we have focused in the Nordic countries are more equality in a material or economic sense. And while in the American or Anglo-American societies, it has been more focus on recognition and in relation to identity and so on.
Please tell us how the feminist movement influenced changes in law in order to achieve gender equality.
The feminist movement started, in history it started much earlier because there have always been feminist activists. But I mean, in modern times, it started in the late 19th century with claiming for the right to vote and to have a citizenship like the male citizenship of being a public person, so to speak, that could be voted to represent the people, but also to vote. And that was what is often called the first wave, but there have been more waves before that. But if we say that was the first wave, so the claim then at that time was for formal equal rights with men. And in the Nordic countries, we received the right to vote in the 1910, 1920s, a bit different among the Nordic countries, where I think Sweden was the latest one. But then during the first half of the 20th century, this so-called formal equality, that law did not treat women differently from men, it was received during a period of years. So in Sweden then in 1976, one of the constitutional acts acknowledged the principle of formal equality. So the law could not treat men and women differently. And that was codified in the Nordic countries around that period in the middle of 20th century. So at that time, when women had got the formal equal rights, then you can say, I would say that was the second wave, at least in academy, because then feminist legal scholars started to realize that formal equality was not enough. And then we needed concepts to be able to reflect upon that. And we said that despite formal equality, there was hidden discrimination of women or hidden inequality. So if we shall achieve full equality as a result, we need to interpret equality in a more substantive way, or we should talk about equality as an outcome or as a result. So then it's not enough to see that the law treats men and women in the same way, because if the laws are constructed out of a male norm, then women will get worse off, so to speak. We can see that the scholarship and the feminist movement in society together actually had that force to change society and change legislation, change the political debate and so on. So there are a lot of changes during this time that acknowledges that men and women are not always the same or have the same conditions, and also construct laws and establish different kind of welfare and political measures to counteract this practical inequality. So when it comes to the Nordic welfare state, one very practical example is that to be able to support for yourself as an adult person, which you are expected to do, there must be someone taking care of the children. If we don't have a daycare service, we can't really go to work. So gender equality in that respect is very practical, and it is not only a matter of legislation, it's also a matter of having this kind of society that deals with the practical circumstances. So if we have a legislation that we have that expects adult persons to support for themselves, and to that is connected every social insurance and so on. So if you work part-time, you get less pension, for instance. So if you're expected to work full-time, you must also see what is required to do that. This feminist movement, together with legal scholars, have pointed at certain things that has to be dealt with in order to proceed in the strive for gender equality. So to make it a bit shorter, after that, I would say that the third wave of feminist movement has been this transformation of, at least in academy, has been this transformation of how we think about law, for instance. So I would say that my thesis, I would put that in the third wave, because it's not only about gender equality or the relation between men and women, but it's also about how we think of law in general. and the relation between law and human being and so on. And after that, we have the next phase where equality between men and women has been extended to equality between more groups, so to speak. And we have this development of the gender concept to include more than men and women. We have, in some jurisdictions, we have construction of a third sex that is non-binary, or perhaps a new category, a third category. So it's perceived in different ways. And also we have this addition of new categories all the time. And the legislation has acknowledged some of these, not all, but, and I would say in the political field, all these new categories added to the previous ones have been acknowledged in the political sphere. So in a project where I took part, focusing on gender equality in the Arctic, there was a lot of, I could see that on the political arena, in the public governing bodies in the Arctic, so to speak, there's a lot of discussion and acknowledgement of the various categories included in gender, and you add one after another. So that's, for me, that is the fourth wave of feminist movement. And maybe you can say that not being negative towards this acknowledge of different categories as such, but I could say that the problem is perhaps that the fourth wave of the feminist movement perhaps has left the feminist movement. And that was really visible in this project about gender equality in the Arctic, that is more focused now on LGBTI issues and intersectionality than it is on equality between men and women. So it's kind of equality between men and women has been not so interesting anymore. And I think that is not a very good development, because only talking about identity and your own identity in different categories it risks to empty the political content of being something. So I think when you talk about gender equality between men and women, it's not about what you are as a person, it's more about how the society is organized. And of course you could make this additional intersectional perspective more political if you focus on the material conditions and the power relations. But I think mostly it tends to be a question of individual identity. And I think the individual perspective is emptying the political potential of both feminist movement and feminist legal scholarship.